So I would like to introduce our first presenter, Dr. Alan Gunther, who completed his MA and PhD in Islamic Studies at the Institute of Islamic Studies at McGill University. He's currently teaching history at Briarcrest College and Seminary, including courses on Islamic history and society, and on the histories of the modern Middle East and modern South Asia. His research projects and publications focus on the history of Christian-Muslims relations in the South Asia. The title of his paper is Justice Mahmood, Negotiating Justice in Colonial India. So Dr. Gunther, I will now hand the stage over to you.
So my dissertation dealt with Sayyid Mahmood, and so I've been interested in his approach to Islamic law and to justice in general, and I will explain that as I go on. In 1882, Sayyid Mahmood was the first Muslim to be appointed as a judge in any of the high courts in India. As such, he took a firm stance against the arbitrary reliance on English law and promoted the preservation as well as extension of Muslim law in India. His father, Sir Syed Ahmad Khan, had risen in the judicial system of the Indian civil service as high as a native of his day could. Wanting more for his son, Sir Syed made sure that he received an education in English and then secured a government scholarship, enabling Sayyid Mahmood to sail to England and study at Cambridge and at the Inns of Court in London. Sayyid Mahmood qualified as a barrister before returning to India in 1872. After several years of working as a lawyer, Mahmood was invited to serve as a district judge, and then in 1882 as a puisne judge of the High Court in Allahabad, the first Indian to serve on the bench there. As the only Indian judge in the Allahabad High Court, he developed a reputation of writing lengthy judgments, elaborating points of law, often in disagreement with his fellow judges who complained that he was taking too long to do his work. Because of that, as well as his drinking problem, he was forced to retire from his position on the bench in 1892 at the relatively young age of 42. But in his capacity as a judge, Mahmood had the opportunity to issue authoritative judgments that were published as judicial precedents in the law reports of his day. Furthermore, he gained a reputation for an independent and insightful understanding of law. He also was invited by the government to comment on proposed legislation. In these positions, then, he was able to play an influential role in the creation of law for British India. I have dealt elsewhere with his understanding of Muslim law, his use of Muslim law in his judgments, and his critique of how the British applied or failed to apply Muslim law in the courts of British India. In this paper, I analyze his judicial work more generally, highlighting several areas in which he sought to promote justice in the colonial context of the British Raj. As the son of Sir Syed, who had earned the respect and appreciation of the British administrators, Mahmood was seen as a young man with promise, as one of the first students from India to complete a legal education in England, and then advance to successive positions of barrister, district judge, and then puisne judge of the High Court. He was uniquely placed to not only provide a Muslim conception of justice, but also to guarantee that his voice would be heard. Therefore, it is instructive to review the record of his legal judgments and his minutes advising on proposed legislation, with a focus on select issues in which he confronted injustice. An abiding concern of Sayyid Mahmood's was the cost of the administration of justice in India, particularly to those too poor to afford the lengthy and hence expensive litigation process involved in numerous appeals. One factor which made it difficult for the poorer and less educated classes to obtain justice for their smaller suits was the increasingly complicated mass of law they were expected to master in bringing their cases to court. While affirming his support for the work of codifying law in India, Sayyid Mahmood expressed his reservations about the impact of such codification on the person seeking justice in a small and simple matter. Codification had been beneficial in rendering substantive law and procedure in India, as he put it, ascertained, well-defined, and ascertainable. I should be the last to deprecate the extension of the policy of codification, for I feel that there is still ample room for the operation of that policy. But with all this, I humbly think that the interests of serious and important litigation have almost completely absorbed the time available for carrying out the policy, and the interests of petty litigation have been practically ignored. He suggested that the results of this neglect had been disastrous to petty litigation in proportion as the body of codified law had increased. The solution he proposed was a system of village munsifs, similar to that which he had observed in operation in Madras during his visit there a year earlier, 1881. This would consist of unpaid village tribunals established to deal with cases involving petty litigation. Another factor which hindered the poor from obtaining justice was the cost of pursuing their cases in courts that were at a considerable distance from their homes. For this, too, Mahmood's solution was a network of numerous village courts to adjudicate cases on the spot. Small cause courts had been established by the government in 1865, and they had proved successful in handling petty litigation in the larger towns and urban centers. But they were too few and therefore too spread out to adequately administer the smaller claims from all the outlying rural areas. Said Mahmood provided a detailed breakdown of all the costs involved in a poor farmer pressing his small suit in a small cause court in a distant town, demonstrating that to enforce a claim amounting to only 20 rupees, a farmer would have to spend almost a third of that amount just to travel to the court and present his case. A network of village courts, such as Mahmood was suggesting, would make justice more accessible. Since those administering justice would be unpaid tribunals or honorary munsifs, there would be no increase of cost to the state. In fact, such village courts would prevent petty litigation taking up the time and expense of regular courts. An added benefit would be that more of the people of India would be involved in the administration of justice and would thus feel that they were having a part in the running of their country. Another issue was the use of the English language in the courts. Said Mahmood regarded it a great misfortune that the language of the high courts was not the language of the people. One of the greatest difficulties in the administration of justice in India, he once declared in a speech to the Allahabad bar, is the circumstance that the language of the highest tribunals in the land is a language foreign to the people and unintelligible to the masses of the population for which those tribunals have been established. End of quote. Although he accepted this reality as one of those aspects of British rule which the people of India have cheerfully welcomed in consideration of the great blessings which it brings, he promoted whatever measures he as a puny judge could do to mitigate its rigor. He likewise exhorted the members of the bar to fulfill their role in rendering intelligible to the people what would otherwise seem to the masses of the Indian population as unintelligible as the decrees of fate. One measure which Mahmood himself took and considered to be of utmost importance was the translation of his judgments into the vernacular language, even if it meant that he would have to reduce his judicial workload as a consequence. By insisting on the translation into Hindustani, he wished to assure the people that although the judges delivered their judgments in a language unintelligible to them, yet they had understood the facts of the case and after due consideration had solved the difficulty of law involved. He added, I feel that justice loses the better half of the ends the moment it ceases to satisfy the people that the judge has grasped the difficulties and complications of their disputes. Although the Indian law reports include relatively few judgments by Said Mahmood on criminal cases, the ones recorded contain some of Mahmood's strongest statements against injustice. One of his concerns was the sentencing of minors to prison. In a case that had not appeared before him in appeal, but rather had been noticed by him in his regular perusal of monthly statements from the lower courts, he discovered that a 13-year-old boy had been sentenced to 5 years of rigorous imprisonment. He had sent for the record of the case in order to determine whether perhaps some other sentence could be awarded the boy that would be, as he put it, conducive to bring him to morality and honesty instead of growing into manhood under conditions such as life in a jail for so young a person involves, end of quote. He suggested the age of 13 was sufficiently tender to enable the prisoner to learn positive notions of morality if given the opportunity. He therefore advocated the establishment of reform schools, as provided by Act 5 of 1876. The absence of such schools hampered the execution of his duties as a judge because this option was not available in his province. His fellow justices fully agreed with him on this matter and urged the government to establish such reform schools, noting that such institutions were working well in the Bengal, where they had already been established. Subsequent correspondence indicates that the government yielded to the pressure of the court and proceeded with the establishment of reform schools. He was also concerned about the rights of the accused to appear in court. In one celebrated case, Queen Empress versus Kofi and others, he dissented strongly with the decision issued by his fellow judges. His main contention was that when the High Court admitted an appeal in a criminal case, the appellant had the right to appear before the court to be heard. The practice of the court, upheld by the other judges, was to dispose of the appeal after the record of the case had been sent for and perused, even though neither the appellant nor his pleader was present. Mahmood noted for the record that the accused were being held without the possibility of bail unless the High Court chose to grant it, and that they were confined in jail, quote, in a fashion in which their legs were tied down by iron chains, not metaphorical iron chains, but solid, actual fetters, unquote. Therefore, the High Court had the exclusive power to enable the accused to appear before it, and if it refused to do so, a serious miscarriage of justice occurred. Before arguing that a careful reading of the existing legislation supported his contention, Said Mahmood appealed to what he termed maxims of human jurisprudence, which he drew from Roman law and which he considered universally valid and of more weight than local jurisprudence or any current legislation. The key maxim was as follows: no one shall be condemned unheard. He furthermore appealed to the saying of Seneca: whoever may have decided anything, the other side remaining unheard, granted his decision may have been just, will not have been just himself. To demonstrate that Indian poets were equally concerned about justice as were the Romans, he likewise quoted an Urdu couplet, which he translated thus: O friend, the day of judgment is near. How then will it be possible to conceal by silence the blood of those killed? Even if the tongue of the dagger will keep silence, the blood on the sleeve will speak out. Said Mahmood stated that he came by this conviction not only through his study of the history of English law, but also as a result of the study of Muslim jurisprudence. He felt justified in introducing Muslim law in this case because, as he stated, that jurisprudence was the standing law of the land when the British rule came to this part of the country, and he was referring particularly to the state of Awadh. Therefore, unless express legislation had been introduced to replace the rules of Muslim jurisprudence, the existing law, even in matters of criminal law, would remain as it was. Said Mahmood appealed to notions of international law and civilization in general to argue that in the absence of legislated rules, specifically abrogating the existing law, Muslim laws of criminal procedure would remain the default law to be followed by the courts. Then, after going on to challenge his contemporaries' interpretation of the relevant legislation, which would allow for the dismissal of appeals of criminal cases without the accused or his pleader ever appearing in court, Mahmood reminded them that the British law which had been introduced was equally subject to abrogation if it proved deficient. He wrote, I think it is necessary for me to say that if it is true, the law of the British India makes it possible for me sitting here as a judge in the first place, by dint of my writ, to order a person to be imprisoned and tied by a chain, then in the next place, to require the mockery of giving him notice, the mockery of asking him to attend, when I, by the dint of the exercise of my own power, have made it impossible for him to attend, and then have the solemn mockery of having his name called out. If this is the law of British India, I hope the sooner it is abrogated, the better. In light of his willingness to accept British laws of evidence as having abrogated Muslim laws, this strong denunciation of British law by Mahmood is significant, as it is his use of the term, as is the use of his term abrogation as the means by which to remove an unjust law. Clearly, he was not one who uncritically supported the British regime or considered all things British to be superior to Indian or Muslim ways. His concern was that universal principles of justice should not be compromised, especially not for the sake of political expediency of maintaining a show of strength by the imperial regime. To conclude, Said Mahmood's resistance to the colonial regime was not one of withdrawing active participation in the British judiciary in India, as that of the ulama, who established their own fatwa issuing institutions when their services to the state were abolished. Nor was it one of active opposition, such as that of Jamal al-Din al-Afghani. His participation in the transformation of Muslim law can best be analyzed as a dialogic interaction with the British colonial power. Though working in a context of colonial domination and exploitation, he was able to use that context to create new answers to new existential problems. His criticism was not as one observing and complaining from the sidelines, but as one actively engaged in the task of administering justice on a regular basis. I recognize that his declarations of appreciation for British rule in India make him an awkward subject for a post-colonial approach to history, but I think that awkwardness is precisely why his voice is one that needs to be heard. Thank you.